I was asked to speak about the consensual elements of tax and customs law in criminal proceedings, and I will provide you an overview on the 4 topics as requested: the position of fiscal authorities in criminal proceedings, the plea agreements in criminal proceedings, and estimates in tax law and its relations to criminal tax proceedings, and the question of self-disclosure. Could we please go to the next slide? Okay.
Just a moment.
Judith, could we please go to the next slide? Thank you. First, you have to know that in Austria, we have a dualism of criminal tax proceedings. We have first the judicial criminal tax proceedings, and on the other side, we have administrative criminal tax proceedings. And as a general rule, judicial criminal tax proceedings have to be applied under 2 preconditions. It is the case if both the offense is an intentional one and the amount of illegal tax reduction relating to the offense is above 100,000 euros. But these 100,000 euros can also be cumulative if several offenses have to be judged at once. If one of these 2 preconditions, intention and tax reduction of more than 100,000 euros, is not given, then the administrative criminal tax proceedings have to be applied. Beside that, there are some specialties, so cross-border VAT fraud always has to be judged in judicial criminal tax proceedings. If we go to the next slide, please. The slide provides you an overview of tax authorities in charge of also criminal tax proceedings in Austria. And you should know that we have a system reform of tax authorities in Austria, which entered into force on 1st of January 2021. Now we got Austrian-wide 5 separated offices within the tax authorities. This is the Tax Office Austria, which is the ordinary tax office, the tax office for major companies, the Customs Office Austria, the Anti-Fraud Office Austria, or the Anti-Fraud Office, and the Supervisory Office for wage-related taxes and fees. The acronyms below the names refer to the German names, so of course they are different to the English names I used. In case of criminal tax proceedings, there are the Customs Office and the Anti-Fraud Office of interest to us. And the Customs Office is in charge of custom-related tax offenses, whereas the Anti-Fraud Office is in charge of all non-custom-related tax offenses. If necessary, I will refer to the latter one in my ongoing presentation. The Anti-Fraud Office has 4 subdivisions. There is the Criminal Tax Proceedings Authority, which is the major one which is in charge of the criminal tax proceedings. There is the Financial Police Authority, which has rather preventive but also repressive tasks. There is the Tax Investigation Authority, which is involved on both sides, but mainly on the repressive one. And there is the Central Office for International Cooperation. If we go to the next. This slide aims to provide you with an overview of the position of the tax authorities in criminal tax proceedings. And there you have to differentiate between administrative criminal tax proceedings on the one hand and judicial criminal tax proceedings on the other. Let me please refer first to the administrative criminal tax proceedings. And I differentiated between the investigation stage, the decision-making stage, which means in case of judicial, the main trial, and the question of appeal. At the investigation stage, the Criminal Tax Proceedings Authority, as being a subdivision to the Anti-Fraud Office, leads the proceedings, and the Tax Investigation Authority, another subdivision of the Anti-Fraud Office, is in charge of implementing certain types of investigation measures. The decision-making authority remains within the administrative tax authorities. Either it is made by a single officer or by a chamber of officers, but still within the administrative authorities. Only the appeal stage needs to be done by the Federal Court of Justice, which is an administrative court. On the other hand, the judicial criminal tax proceedings, there is the public prosecutor in charge of leading the investigations, and the tax investigation authority within the Anti-Fraud Office takes over the role of police. The main trial takes place in front of the regional criminal court, and the appeal at the Supreme Court of Justice or the higher regional court. What is interesting here is that the Criminal Tax Proceedings Authority has ex officio the role of a victim claimant within these proceedings. So it has the victim's rights, it has the right to legal remedies, it has the right to be present at the proceedings, and there are no limitations of access to the file to the Tax Investigation Authority. If we could go on. I would like to come to the question of plea agreements. And if you take a look at my headline, I wrote no plea agreements in criminal proceedings, because the Austrian Supreme Court of Justice considers plea agreements as being an abuse of public authority, and I quote, in blatant contradiction to the fundamental principles of Austrian criminal procedural law. The abuse of public authority is a criminal offense by section 302 of the Austrian Criminal Code. And this means that a civil servant who, with the intention of thereby harming another person's right, knowingly abuses his public authority of enforcing the laws when exercising this authority, is punishable by imprisonment from 6 months to 5 years. What is the core message of that? Well, the core message, as interpreted by the text literature, seems to be that plea agreements are illegal as long as they violate the ex officio investigation principle. If we go to the next slide, please. We have a somehow comparable situation, at least on a first glance, in tax proceedings. The Federal Administrative Court stated in some decisions that settlements on the content of tax obligations are void if not provided for explicitly by the laws. And likewise, the internal regulations of the Austrian Ministry of Finance state, in the context of an external audit, commitments in tax or financial criminal proceedings, e.g. about impunity, collective and recovery measures, other future behavior of the authorities, are not provided for by the law and are therefore legally ineffective. If you go to the next, please. But does this mean that there are no consensual elements to be found? Well, an implicit consensual settlement in tax proceedings could be seen or located in the rule on complaint, the waiver in tax proceedings. You see there section 255 of the Bundesabgabenordnung, federal tax law, the filling of a notice of appeal can be waived. And the somehow consensual element could be found in paragraph 2 of this article. Because the precondition to the waiver is that the waiver at the time of its submission is aware of the content of the notification to be expected. In the case of tax notices, the basis of the fixing, the amount of the tax, and the deviations from the previous fixings. So somehow you need consensus on both the facts and the amount of the tax. Does it fit to the evaluation of abuse of authority, as I presented before? If we go to the next slide. Well, the basis for consensual elements could be seen in a twofold obligation to establish the facts for the tax. There's, on the one hand, the tax authority's obligation to investigate. On the other hand, the tax debtor's obligation to declare. So there's somehow a consensual establishment. To be legal, such a consensus needs to be within the tax authority's margin of appreciation. And in literature, you find potential topics of those consensual elements: the disputed factual questions, disputed legal questions, and the future handling of the factual and legal questions. But this leads to our topic. It may also the exclusion of criminal tax proceedings being arranged for by such a settlement. The Federal Administrative Court states that this is not possible. The law, the court says, the law does not provide for a waiver of criminal punishment by consensual tax settlement. So based on this verdict, the answer has to be no. If we go to the next slide, please. Are there any consensual element in criminal tax proceedings to be found? Again, you have to differentiate between administrative criminal tax proceedings on the one and judicial criminal tax proceedings on the other hand. Let me start with the judicial criminal tax proceedings. Consensual elements beside the exclusion of plea agreements by a federal court law, case law. Of course, we have a settlement by diversion in the ordinary criminal procedural code. There are some preconditions. I'm not going into detail now, looking at the time frame. This settlement by diversion can be taken place in the investigative stage as well as at main trial. You don't have those measures of diversion in administrative criminal tax proceedings. But at the decision-making stage, already still in front of the administrative authorities, there are some elements of consensus. There is the possibility for written punishment order, which especially where especially a precondition is where especially the appeal can be waived in advance if the content of the order is known in advance. And you know that from my last slide. There's also the possibility of simplified written punishment orders in some customs proceedings under very strict preconditions, but based on confession. And as a somehow consensual procedural element, there is the possibility to waive oral hearings. If you go to the next slide. Let me come to the topic of estimates in criminal tax proceedings. No, yes, thank you. Section 184 of the federal tax law states that insofar as the tax authority cannot determine or calculate the basis for levying the tax, it shall estimate this. In paragraph 2 and 3 of this section, you find particularly situations where such an estimate can take place, especially where the tax debtor is unable to provide sufficient clarification or refuses to provide further information, or the tax debtor does not present books or records. If we go on the next slide, please. How about the difference between estimates in the handling of estimates in tax proceedings and criminal tax proceedings? I tried to present you the difference along 4 categories. First, the burden of proof. Second, the level of proof. Third, the cooperation obligations of the concerned people. And fifth, the amount. Whereas in tax proceedings, as I showed before, there's a shared burden of proof. The tax authorities are responsible for establishing the facts that caused the tax liability, and the tax debtor has the obligation to establish the facts reducing the tax amount. We all know that in criminal proceedings, the facts needs to be established by the authorities. As regards the level of proof in tax proceedings, there is sufficient the standard of most likeliness or probability, whereas in criminal proceedings, of course, we need the conviction of the facts in order to put a verdict. As regards cooperation obligations, in tax proceedings, of course, the tax debtor has the obligation to fully cooperate, whereas in criminal proceedings, and we will hear about that more at the end of the afternoon, there, of course, the nemo tenetur principle applies. And as regards the amount of estimates in tax proceedings, surcharge charges are likely, whereas, of course, due to the necessity of conviction, no surcharges can take place in criminal tax proceedings. What does it mean? It means that at the very end, estimates in criminal tax proceedings cannot be transferred one-to-one to criminal tax proceedings because there are different rules which they are based on. If we go to the next slide, let me please finally come to the question of self-disclosure in criminal tax proceedings. You find a rule on self-disclosure in Section 29 of the Financial Criminal Code in Austria, which states, whosoever is liable of financial offenses is exempt from punishment insofar as he presents his misconduct voluntarily disclosure. It is excluded when he is caught in the act. Precondition to such a self-disclosure is that the disclosure includes all the facts necessary to determine the tax amount, and the payment of the tax amount needs to be done within 1 month after disclosure or authorities' notification. Self-disclosure as an exempt from punishment is excluded if investigations already started at the time of disclosure against the reporting party, others involved to the offense or the offense. They are also self-disclosure is also excluded if the facts were already known and the reporting party was aware of that, or if the disclosure relates to an intentional tax offense and has not been made at the beginning of a tax authority's audit measure, or if a voluntary disclosure has already been made once with regard to the same tax claim, where the exception of advance payment, with the exception of advance payments. I tried to stick to the timeline. Hopefully, I could demonstrate you that there are some consensual elements. If you go to the next slide, please. There are some consensual elements in tax as well as in criminal tax proceedings, but especially in criminal tax proceedings, the exclusion of plea agreement formally limits this very much. Thank you very much for your attention. I'm happy to answer your questions.